Okay, good afternoon. Welcome to docket number 230139, REO1. Here's consideration of civil penalty and enforcement action against the Connecticut Light and Power Company doing business as Eversource Energy after an investigation of an accident. My name is Chairman Marissa Gillette. I'm joined in person today by my colleagues, the Vice Chairman Jack Bukowski and Commissioner Michael Karen. We are here this afternoon for a hearing with respect to a notice of violation issued by the authority in the underlying or in this docket. I have an agenda in front of us today. We have one witness and some cross-examination scheduled. I will open by asking for appearances, and then we will address administrative matters and any public comment before we move into cross-examination. So appearances, please.
Thank you, Chairman Gillette. Dan Crisp for Eversource.
Okay, thank you.
Allison McCorney for Office of Consumer Counsel, joined by Tom Wheel.
Thank you. Any other parties who would like to make an appearance? Thank you. Are there any administrative matters before we begin?
Yes, Chairman Gillette, I do have one. First off, I want to thank the chairman and the vice chairman and commissioner for appearing today and for the OCC for their participation in this docket. I know there's not a lot of money at stake in this NOV, and that considering there was a subsequent NOV issued and a subsequent proceeding in the underground investigation, and that the calculation of the penalty has changed, which would, if consistent with the reasoning in the underground docket, push the penalty in this docket down even less than what it is now. If there is a question as to whether we would still like to exercise our rights to a hearing, the answer is yes. Eversource has reported consistently over the past 10 years, and for the first time, hearing that the authority did not or took issue with the way that we reported, issued a notice of violation. So we would like to exercise our rights to have this hearing today.
Okay, thank you, Attorney Crisp. I appreciate the clarification. I don't think we were at question about whether you were interested in exercising the hearing. So we will proceed. Are there any administrative matters? If not, let me pause and see if there's any public comment. If not, if Attorney Crisp, if you could introduce your witness, I will swear him in before we adopt testimony.
Thank you, Chairman Gillette. Eversource's witness is Mark Bonjuklian, Manager of Distribution Projects and Programs.
Thank you, Mr. Bonjuklian. If you could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you, sir. Attorney Crisp, adopt any pre-filed materials, please.
Thank you. Mr. Bonjuklian, can you please state your name and title for the record?
I'm sorry, can we make sure the mic's on and pulled close to the witness, please?
I'm Mark Bonjuklian. I'm the Manager of Distribution Projects and Programs.
And Mr. Bonjuklian, in connection with this proceeding, did you sponsor pre-filed testimony and exhibits?
Yes, I did.
And do you have any changes to those materials at this time?
No, I do not.
And do you adopt those materials as your sworn testimony here today?
I do.
Thank you. Our witness is available for cross.
Okay, thank you. We will have cross-examination first by the Office of Consumer Counsel, please.
Thank you, Chair. Mr. Bonjuklian, in your pre-filed testimony, we just said this, you state that you're the Manager of Distribution Projects and Programs for Eversource. In that role, what is your involvement with the company's accident reporting procedure?
So my involvement is I'm overseeing that process, the accident reporting process. There's an employee that prepares the reports for circulation, and I oversee that employee's accident reporting duties, and I sign off on the accident reports that are submitted.
Okay, just so for my clarification, so you review the drafts that are submitted essentially?
Yes, yes. Myself and several others, including others in engineering and legal, and there's a whole process involved, but I generally oversee that process through to signing off on the completed reports.
Okay, thank you. So this hearing is regarding an accident involving a Connecticut light and power pole, which occurred on January 17th, 2023. Just have a couple questions. So from my understanding from the report, car was driving down Greenwoods Road in Norfolk, Connecticut and collided with a pole. Is that right?
Yes.
Okay. About what time did the accident occur? If you're aware.
I don't know exactly what that time was. I would have to refer back to the report.
Okay. I believe the report states 2:30, if I'm recalling
So,
correctly.
Mr. Van Jucklin, do you want to refer to, I think it's exhibit maybe ES3?
Yes. So in exhibit ES3, we have the immediate report for the incident on Greenwood Road in Norfolk. And we show here that the time of the accident was 2:30 p.m. on January 17th.
Okay. What's your understanding of how the accident occurred?
I can't really speak to how the accident occurred.
Do you know how many people were in the car?
My understanding is it was reported that there were two individuals in the vehicle.
Okay. So the collision, so the car hit the pole. Then what happened? Do you know?
I'm sorry. Can you repeat that, or can you clarify that question?
So I'm sort of trying to understand how the accident unfolded a little bit. So the car hit the pole and then, did a wire fall? Did how essentially was the utility involved?
So if I could interject for 1 second. So Mark Von Jucklin is here as our witness for our accident reporting process. The persons who would have direct knowledge of the specifics of the accident would be those involved in the response specialist organizations in the System Operations Center.
Okay.
So Mr. Von Jucklin he can give answers based on his memory, but he's not involved with the actual accident response.
Okay.
I'm sorry, let me just understand the objection. So Attorney Chris, does that mean that the company is not contesting the facts as they were outlined in the report, since you're not producing a fact witness about the investigation itself?
So we produced fact witnesses in the underlying docket, and this NOV concerns our accident reporting process. To the extent the information is in the accident reports, Mr. Von Jucklin is free to speak to that. But if it's about the details of the accident, like what happened during the response, he would not be able to speak to that.
Okay, so your position, I'm still trying to understand the nuance that you're trying to strike here, because the company has contested the accident reports, but if you're not producing a fact witness to contest whether you were or were not able to, whether you did or did not have knowledge for specific portions of that report, I'm trying to understand.
I apologize, Chair. That's not what I'm trying to say. What I'm just trying to clarify is that Mr. Von Jucklin can speak to the contents of the reports as reported to PURA, but if it concerns details about responding to the accident, like what occurred actually on the scene, that would be for the witnesses that we produced in the underlying docket, who manage the RSO organization and the SOC. Okay,
So to be clear, the company cannot then contest the facts as they were outlined in the underlying report, because you're not producing a fact witness on the underlying.
Correct. We're not contesting that.
Okay, thank you.
I'm sure.
So as I'm understanding this, so if the witness doesn't actually know the answer, you can simply say he doesn't know the answer based on the question and pertaining to facts of the underlying docket.
He can.
Right. Okay.
Okay. So bearing in mind that discussion, if you're aware, do you know if there was a live wire involved?
So yes, my understanding is that there was a live wire involved as a result of the vehicle versus pole accident, and that there was entrapment due to an energized live wire, entrapment of individuals in the vehicle. That was what was reported to us.
Okay, just for my clarification, so when you say entrapment in the context of a car versus pole sort of accident, what does that mean? You know, are the individuals able, under what circumstances are the individuals able to get out of the car? What is required?
So what would be required for this safe exit of individuals from the vehicle would be for Eversource to respond, Eversource first responders, our response specialists, to respond to the scene, make the scene safe, and let the incident commander know that the scene is safe and that the vehicle can be approached and the occupants removed safely.
Okay, so it'd be safe to say that Eversource responders would sort of work in conjunction with any other emergency responders in a situation like this?
They would all work together on the scene, yes.
All right, thank you. Let's see. Do you know if anyone in the car received medical attention following the accident? Again, if you don't know, that's fine.
We understand that at least one or both of the individuals were transported to a medical facility. We don't know whether it was for observation or whether they received attention or treatment or exactly what resulted from that.
Is it your understanding that the transportation occurred via an ambulance?
I believe one was via ambulance and I believe one was via helicopter.
Oh, okay.
That's my understanding.
Okay. Is there any procedure Eversource has to look into injuries stemming from an accident like this, either for employees or non-employees?
Well, certainly for employees, there would be a whole process that the company would be involved with if there was an employee injured on the job. For a non-employee, it's very different in that they're, our responders are on scene. Their responsibilities are first and foremost to make the scene safe. Secondly, to restore service if there was any loss of service. And thirdly, to make any necessary repairs. So in that process, they're typically not going to know or be told about specific injuries. And in fact, because of HIPAA laws, that information is typically not shared with us.
Okay. So you said there would be a procedure for injuries for employees. Can you tell me about that procedure?
I don't have the specifics on that, other than that, we would certainly it would be communication back through supervisory channels and likely the safety department. And the safety department would probably be better positioned to speak to their specific procedures.
Okay, no problem. Okay. How was Eversource notified of this accident?
We received a call came in on the emergency call came in, and it was relayed to us. My understanding is it came in as a car versus pole with potential entrapment.
Okay. And what entity notifies Eversource of this?
Typically, it's the police or fire or whoever first responder responded first to the scene. That would be typical.
Okay. So for this accident, again, on January 17th, do you know when Eversource was notified?
Yes. So again, referring back to the immediate report, we're showing that the time that we're reporting is 2:30 p.m., which, we're typically reporting the time that we were notified. So we don't exactly know the precise moment of the accident, but we typically report that as the time that we received notification of the incident.
Okay. Okay. So it
would be approximately or
Approximately
sometime
2:30.
shortly before 2:30 p.m. is what we would assume to be the case.
Okay. Thank you. Okay. And so we asked, typically this would be emergency services, whoever responds would notify Eversource, and who at Eversource is notified?
So the call comes in, and if it typically goes to either a call center, or if it's they call in on an emergency line, which the first responders have, that would typically go to the system operations center, who would take that call.
Okay. So just for my clarification, so around 2:30 on the 17th, System Ops received a call from emergency responders letting the company know that the accident took place. That's your understanding, right?
I understand.
Okay.
Yes.
Thank you. Is there ongoing communication after that notification, or is it a one-time notification?
I think that would depend on the circumstance.
Okay.
I can't speak directly to that because I'm not involved. I can't say for sure.
Okay. So System Ops gets this call. What's the internal procedure at Eversource once System Operations is notified of an accident like this?
Well, again, so the system ops folks can speak more directly to their procedure, but I can tell you that they would attempt to get as much pertinent information as they could from the caller to try to determine exactly what took place and specifically what resources can best address the issue and how we could best, resolve quickly and safely. And once they got that information, they would put into place their process as quickly as possible to get the appropriate resources dispatched to the scene.
Okay. And it's your understanding that that's what happened on January 17th?
Yes.
Okay. How did Eversource reach out to PURA regarding this accident?
So Eversource, I am aware that Eversource filed an immediate report several days after the accident. I believe it was on the 20th, if I'm not mistaken. You give me one moment.
Sure.
So yes, we filed an immediate report on the 20th, January 20th, after the accident.
Okay. And forgive my ignorance, how is that report filed? Is it emailed? Is it faxed? Is it?
So there's a online PURA system that we use to communicate that information.
Okay. Okay. So around January 20th, Eversource notified PURA of this accident via PURA's online portal, right?
Yes,
Okay.
yes.
And similarly, I saw the 5-day report that's also in the record. Was that submitted the same way?
Yes.
Okay. And do you know what date that was submitted?
I believe that was on the 27th, if
27th.
I'm not mistaken. Yes, that was filed on January 27th.
Okay, thank you. So you had sort of already talked about this a little bit when Eversource is notified about an accident that, pertinent information is gathered. Is there any ongoing gathering of information from Eversource, or is it sort of all, I guess what I'm trying to say, is there additional fact finding about such an accident after the immediate notification?
Fact finding for purposes of, can you please clarify?
Sure. So after the immediate notification, maybe you don't know if there were any, so we'll use this as an example, you don't know if there are any injuries or you don't know if there was any particular property damage. Are there any sort of procedures in place for Eversource to look into those questions after the initial notification period? Does that make sense?
I think so. So I think it would depend on what information we're referring to. If it were injuries, we don't typically go and we're not pursuing that information. If there was something that was obviously lacking from the immediate report, that was something that we were perhaps going to follow up on, we would follow up and enter that into the 5-day report.
Okay. So we sort of already talked about some of this stuff. The company routinely checks whether anyone's injured in an accident, right? Both employees and non-employees.
When you say checks, I mean, certainly for employees, again, we would know, but for non-employees, that's typically not necessarily shared with us.
Okay, so whether you know if non-employees are injured would sort of depend on what information is conveyed by the emergency dispatch?
It's possible that in the process of completing their repairs, it's possible that we may learn of an injury, but we don't typically have firsthand knowledge of non-employee injuries.
Okay.
It's typically not shared with us.
Okay. And in this accident, did Eversource verify that no employees were injured?
Yeah, I don't believe that we had verification of that either way.
Okay. All right, I think that's all the questions I have. Thank you, Mr. Bonjuklian. I'm going to turn it over to my colleague, Attorney Wheel.
Thank you. I just have a couple of follow-up questions. You responded that you can't speak to how the accident occurred. So is determining how an accident occurred not part of the company's standard investigation protocol?
As far as determining how a vehicle came into contact with a pole, no, that would typically not be part of our protocol, no.
Okay. You also, Attorney McCorney asked you a couple of questions about the information available to you about non-employee injuries. And you responded that the company typically doesn't have access to that information because of HIPAA and otherwise. Does the company seek that information as part of its protocol?
Not to my knowledge.
You testified that when Attorney McCorney was asking you some questions about the process for how the company first receives notice about an accident, you responded that typically it would be the first responder who notified the company. But who notified the company in this instance?
I don't have that information in front of me.
You also, similar question, you testified that when a call comes in, it typically goes to a call center or system operations center if it's an emergency line. Do you know which of those was the case in this instance?
I do not know for sure. Would be most likely go to the system operations center because of the severity, but I would have to say I'm not 100% sure.
Can you explain what you mean by severity?
Well, typically, again, if it comes in from emergency responders and they call in on the direct line that goes into the system operations center, they have a line that would go directly there, then the system operations center would get that call.
Okay, but a second ago you said because of the severity, it's likely that that's what happened in this place. I'm just not sure what you mean by the severity.
Well, depending on who calls it in and what number they call in. So when I say severity, perhaps that's not the best word to use. It's depending on how it's called in.
Okay. Attorney McCorney also asked you if there's a one-time notification from dispatcher, whoever informs the company of an accident, or whether it's sort of an ongoing communication about it. And you responded, I think, that it would depend on the circumstance. What happened in this instance? Was it a one-time notification or was there any further communication?
I don't have that information.
Was the immediate report filed with PURA the first communication to PURA regarding this accident?
To my knowledge, I would say yes.
Okay. You also responded to Attorney McCorney that the company doesn't pursue information on injuries as part of its investigation. And I think the question was in the context of pursuing further information as to something like injuries beyond the initial response. Would that also pertain to employee injuries, that the company wouldn't follow up to determine whether there had in fact been employee injuries?
If an employee is injured on the job, the company is certainly obligated to investigate. Sure, it's entirely different than a non-employee injury, especially specific to a car versus pole.
And I think you mentioned that it's a kind of a different unit maybe that develops that information, but when you say investigate, if an employee is injured on the job, how does that unfold?
Again, that's not under my purview. So I don't want to speak to that process.
Okay, and the last, sorry to harp on this one issue, but you also testified again that non-employee injury information is not typically shared with the company. Do you know whether that information was shared with the company in this instance?
I do not believe that it was.
Okay. I believe that is the last question from the OCC. Thank you to the witness panel.
Thank you. Attorney Keenan, anything? No. Okay, I have got a couple of questions, please. Mr. Bonjekin, can you remind me how long you have been with the company and specifically how long you've been with the company in a role that has the same responsibilities that you exercise now?
Sure. I've been with the company since 2008. And I've been in this position since early 2022.
Early 2020, like Q1?
Yeah, I believe it was February to March 22 when I took this latest position that I'm in today.
Thank you. So is it fair to say that any communications from the authority to the company regarding accidents or deficiency of accident reporting would cross your desk?
Well, so I've been my position that I'm in overall with the company since February again of 22. It was in June of 22 that this position took over the accident reporting responsibilities. So it's from June of 22, actually it was about mid-June of 22 when we assumed, and I started signing off on the accident report submissions.
Okay, so if the authority directed a letter to you and your company on June 23rd of 2022, notifying you that the way in which the company reports its accidents is deficient, that would have been brought to your attention.
If you're referring to the letter with respect to the Waterbury and Middletown incidents, is that the letter you're referring to?
I'm reacting to testimony that your lawyer attempted to provide earlier, but was also, I think, alluded to in your pre-filed testimony, in which there was an assertion made that the company had never been notified that its accident reports were deficient. And I am attempting to point out that that is not true.
So if you're referring to the June 23rd letter of 22, yes, I am familiar and I am aware that the authority did seek additional information with respect to 2 incidents that occurred in 22. But I'm also aware that nowhere in that communication did the authority indicate a dissatisfaction with blank spaces in our reporting, which we had been, quite frankly, reporting in that manner for at least 10 years. So I would say that was the first, this docket and this NOV was the first indication that we had that the authority was looking for, was not satisfied with our method of reporting and was providing some guidance as a contrary to what we had been submitting and the authority had been accepting of.
Great, thank you. I'll come back to that. Let me just back up a little bit and retread some ground earlier. I think we covered with the OCC's attorneys that a little bit about the entrapment. So let me just repose these questions to make my final question clear. Were you able to, I think you testified a little bit ago that the vehicle became entrapped after striking a utility pole. Was that your testimony?
That's our understanding.
Okay, so can you point me to where in either the immediate or the 5-day report that it indicates that a vehicle struck the utility pole?
So in the immediate report, the description of accident reads, Eversource received notification of a motor vehicle accident with entrapment. And that would be typical of how we reported car versus pole entrapment incidents, again, over many years.
Okay, well, I'm just gonna stick to the time frame in which you stated you had direct responsibility for this, so and I'll ask specific to this question, to this docket, please. So I just want to go back to my question. I don't think you read something that said that the vehicle struck the utility pole. But I just want to make sure I'm abundantly clear here. Does the immediate or 5-day report indicate that a vehicle struck a utility pole?
It indicates there was a motor vehicle accident.
Okay, thank you. And earlier you shared that you believe one of the victims was transported via helicopter, I believe it was a Lifestar. Is that correct?
That's my understanding.
Okay, and the other victim was transported by ambulance, was your testimony, I believe?
That's my understanding.
Would a person typically be transported by Lifestar for observation?
I'm sorry, I can't speak to that.
Okay. Would the information that we just discussed about being transported by ambulance and being transported by Lifestar be relevant as to the extent of the victim's injuries?
We would not know the extent of any injuries or whether there were injuries. We would not know that. That information is not shared with us so that we could report without speculation.
Okay, so that's what I was just trying to ask about. So
we would not have firsthand knowledge. We would only be speculating.
you'd be speculating that a victim was transported by Lifestar.
No, the reporting does not ask if a victim was transported. The reporting asks if there were injuries, and we'd be speculating as to the extent of injuries, whether there were injuries, name of injured. We don't have that information.
Okay, I think we're talking past each other. The report specifically asks for what, in your opinion? Or
Well,
if
the
you could,
report asks for number of injured persons, injured person's name, injured person's age, how the injured person was treated. Of course, we don't know without speculating whether there was an injured person's contact information.
okay,
So until we have definitive firsthand knowledge that there was an injury, an injured person, there's nothing to report.
were there Eversource employees on site of the accident?
We responded, yes, to make the
Okay.
scene safe.
Okay. And they saw a Lifestar helicopter and an ambulance on site, yes or no?
I was not there. I don't know what they saw.
Okay. Can you point me to where in either the immediate or 5-day reports that it indicates 2 victims were transported to medical facilities?
That is not reported.
Okay. On page 15, you state Eversource did not know and still does not have firsthand knowledge regarding the extent of any injuries to the vehicle's occupants. Is that an accurate representation of your testimony?
I believe it is. What line may I ask, please?
On page 15, let's see.
Oh, here it is on line 10. Yes, that's correct.
Does the regulation require the company to report the extent of injuries?
To the extent that we have known firsthand knowledge.
The regulation, in your opinion, requires the company to report the extent of injuries? Does the witness have a copy of the state regulations pertaining to accident reports, or are you otherwise familiar with the accident reporting regulations, sir?
Yes,
Okay, so regulation 16-16-3 subsection E7 requires all known significant facts or information relevant to the cause of the accident or the extent of the injuries or damage. In that context, what do you understand the term relevant to mean?
So can you please repeat where are you within the regulation?
Sure. 16.16.3,
Yes.
subsection E7.
Yes, all known significant facts or information relevant to the cause of the accident or the extent of the injuries or damages.
Thank you. What do you understand the term relevant to mean in that context?
I'm not sure I understand specifically what you're asking.
Okay, let me back up a second. Accident reporting falls under your purview, sir?
Yes.
Okay, I'm asking if the regulation pertaining to accident reporting, if what you're in, how you implement this, the sentence or the phrase, information relevant to the cause of the accident. What is your interpretation of the term relevant?
Well, again, in this particular example of a car versus pole, the relevant information would be that it was a vehicle versus pole accident.
Okay, which you conceded a few minutes ago, you don't actually know that the car hit a pole in the report. But let me say more broadly, I'm not asking specific to this docket. I'm asking how you interpret and carrying out your duties, what the word relevant means. Information relevant to the cause of the accident. When you are completing accident reports, what is your interpretation of relevant?
Well, my interpretation of the word relevant, I mean, I'm not sure if you want me to give you a definition. I mean, it's
Okay, fair enough. Let me try an example. So if a person fell and you didn't know the extent of their injuries, would you consider it relevant that they fell from the first step or the 10th step?
that would seem relevant.
Okay. So bringing it down to this specific accident, do you think it's then therefore relevant that an injury, that a victim of the accident was transported by ambulance and one was transported by LifeStar?
So again, until we know that there are injuries, we have firsthand knowledge, then we don't report, we don't speculate. So if we don't have firsthand knowledge that there's injuries, then there's nothing to report. We would only be speculative. It would only be speculative.
Okay, so I'll circle back around to my first question, which is, do you think that someone would be transported by LifeStar if they were not injured?
Again, I don't know if they would be, for whatever reason, they might be transported, whether it was for observation. We can make assumptions, but we don't fill out reports based on speculation without firsthand knowledge.
Okay. I'm not sure I'm getting my exact question answered, but maybe I can move on here. So just to summarize, your position is that the company had no information relevant to the extent of a victim's injuries in this case, meaning that you did not consider it relevant that one victim left by ambulance and one victim left by LifeStar.
I would say based on the manner in which we were trained and we had been reporting for many years, that unless we had specific firsthand knowledge of injuries, that we would not enter any information into the report.
Okay, and again, I hear you say many years, but we've already confirmed that you've only been in this position since June of 2022. Is
Right,
that
but the
correct?
training that we received was from employees that had been doing this for an extended period of time, and they provided the guidance based on past practice.
I'm going to go back to your pre-filed testimony, please. On page 16, you state there were no employee injuries that transpired in connection with the Norfolk accident.
That's correct.
Is that correct? Okay. You then go on to state Eversource confirmed that there were no employee injuries in an interrogatory response. Is that correct?
I believe that's correct.
So in other words, the company provided information and then subsequently updated or confirmed it to the authority, correct?
If we responded to an interrogatory,
Okay. But you also say that the fields were left blank as Eversource had no such information relative to the Norfolk accident, correct?
well, there were, so our training was, if we did not have any information that was responsive to the question, we didn't have any known substantive information that was responsive to the question, that the field was left blank. We
Okay,
had no reason to believe that PURA preference was otherwise. We now know differently, and we're certainly reporting in a different manner based on the recent guidance.
okay, thank you. So let me just pull it back to this line of questioning. So did the company have information regarding employee injuries or did it not have that information?
The company knew that there was nothing reportable there were no reportable employee injuries, and therefore there was nothing to report.
Okay, so can you point me to where in the immediate or the 5-day reports it indicates what you just shared with me? Meaning that Eversource had confirmed that there were no employee injuries.
So the regulation requires us to report known injuries. I don't remember seeing anywhere in the regulation where it requires us to confirm positively that there are no injuries, right? It requires us to report any injuries. And because there were no injuries, then nothing was reported.
You left it blank.
It was left blank, as we had been trained to do, and has, again, we've been doing for many years, and without question from PURA.
Okay, so as opposed to indicating that there were no injuries or writing in you opted to leave it blank.
Exactly. We are now doing differently because we now understand that PURA's preference is that we report in a different manner and we enter something in each field, and we're happy to do that.
Okay, on page 15, you state that this is consistent with Eversource practices of reporting vehicle versus pole major accidents, and I think we've been covering that. Is that correct?
Yes.
So as part of this practice, what other information does the company provide via blank fields?
Any information or question or field on the form where we don't have known firsthand information to report has been left blank. That's been our manner of reporting. And that's what we've done. So it would depend on the specific incident. If we have known information, we report it. If we don't have known substantive firsthand information, we've left it blank. That was the method up until fairly recently.
Okay, on page 19, you state Eversource has reasonably relied to its detriment on the fact that PURA accepted the method the company used to report accidents. My question is, did PURA ever affirmatively state that leaving report fields blank was acceptable?
Well, I can tell you that in your June 23rd letter, when you asked for additional information regarding the Waterbury and Middletown incidents, you specifically asked for additional clarification and information in some fields that we had responded to, but there was no mention on any concern over the blank fields. So again, we would have no way of knowing your preference that we don't leave a field blank when we don't have reportable information.
Okay. So another way to state your position is that the company assumed that the absence of an enforcement action constitutes acceptance of noncompliance.
No, our understanding based on the regulation was that we were to report known facts where we had known firsthand knowledge. And that's what we did. So anywhere we had firsthand knowledge, we complied with the regulation by reporting it.
Okay, so
That's the way we interpreted the regulation.
the way you interpret it. So my question a moment ago, did PURA ever affirmatively state that leaving report fields blank was acceptable? The answer to that is no. It's your interpretation that a lack of enforcement action constituted affirmation of your approach.
I mean, I'll leave it to council to speak to, our interpretation of PURA's action or non-action. But again, our training was that, historically, we had always left those fields blank if there was no reportable information.
Did PURA conduct that training
No, that was conducted internally.
internally? Okay. Is it your position that PURA can only enforce a regulation if it levies civil penalties in all previous instance of noncompliance?
I would defer to council on that question.
Are you raising an objection to my question? I don't want you to respond to the question. I'm asking if you are objecting to me posing that question to your witness.
Well, the witness is not an Eversource attorney. He cannot give an Eversource legal opinion. He can speak to what he understands based on the guidance that we've provided him. But if I have not provided him any such guidance, then he cannot respond to any question.
Okay, I appreciate you raising that distinction because your witness's pre-filed testimony contains quite a number of legal conclusions and observations. So if your witness is being offered to testify to legal observations and conclusions, then that's why I'm posing to him the question. So I will ask again and overrule the objection, and your witness can answer or not. But based on the fact that the PFT offers testimony on a number of legal issues, including alleged detrimental reliance and regulatory interpretation, I'm going to ask the question again, which is it your position that PURA can only enforce a regulation if it levies civil penalties in all previous instances of noncompliance?
I would say we relied on the past practice that was accepted by PURA and
Accepted, sir?
when we filed reports, we filed reports over a 10-year period, which I'm sure were reviewed, and there was no objection or direction from PURA to file otherwise. Again, I'm not an attorney, but I think a reasonable person would assume that, or would come to the conclusion that there was no dissatisfaction with our method of reporting.
Okay, I just want to drill down. I apologize for interrupting a moment ago. That was not appropriate. But your use of the word accept, again, brings me back to the question I had 3 minutes ago, which was, did PURA ever affirmatively state that leaving report fields blank was acceptable? And I believe the answer was no. So the use of the term accept let me ask again, did PURA ever affirmatively provide indication to the company in a written communication that the way you complete the reports or conduct the trainings is appropriate?
I don't think PURA ever provided any guidance as to what their preference was.
Did the company ever ask for guidance or interpretation of the regulations?
Not since I've been involved in the process.
Okay. So on the specific question of, can PURA enforce a regulation if it levies civil penalties in all previous instances of noncompliance? You don't have a yes or no answer to that question. Is that accurate?
Sorry, can you repeat the question one more time?
I'm happy to. The question was, can PURA only enforce a regulation if it levies civil penalties in all previous instances of noncompliance? I was looking for a yes or no answer, and I'm not sure that I've,
Yeah, I'm not sure what, I don't know that I can answer that yes or no.
okay. Okay. Maybe the last question then, in our last exchange, you mentioned what a reasonable person would do. And I appreciate you bringing that back up because I'm still hung up on this commentary that a reasonable person would not understand that transporting a victim by Lifestar constituted some kind of injury. And it remains the company's testimony that it was not a relevant piece of information, because if it was relevant, it would have to be conveyed on the report. So I'm just ask this one more time. If the victim was transported via Lifestar and the second victim was transported via ambulance, was not relevant information in the company's opinion.
Again, the training we received was unless we had specific firsthand knowledge, confirmation of injuries, that we would not report. That's the training that we received.
How does that, in your opinion, comport with the regulation that we just went through? All known significant facts. Is it a fact that a victim was transported via Lifestar?
I'm aware that's my understanding, yes.
Is it relevant that the person was transported via Lifestar?
Well, again, until we had confirmation that there was injury, we would not report.
Okay, all right. Thank you very much for answering my questions, Mr. Vice Chairman.
So I do have one quick, has there been any litigation from the victims in the accident towards the company since the accident? Has there been any lawsuits?
No,
No correspondence from their legal?
no.
And the other things, when you respond to, I'm in Norfolk, Connecticut, I'm very familiar with, it's way out. Your trucks don't have sirens or no dispensation from the state to go there at an excessive rate of speed or anything like that.
No, our witnesses in the underlying docket that they are driving large bucket trucks. There are no sirens attached. Speed limit is 35 miles an hour in that corner. They're not allowed to, when
Chris, I'm sorry to interrupt. I apologize, but you cannot answer a question. You're not a sworn witness in this matter. So if the Vice Chairman would like to direct his question to your witness,
I can do that.
Sure, yeah, I
You
mean,
can't answer, you can't answer.
no, we have to obey all
It's
speed.
very relevant.
Yeah, we have to obey all speed limits, and we have large vehicles that, you know, we need to take great care in driving. We don't have, you know, the ability to bypass traffic laws. We don't have sirens or lights, or unfortunately, you know, that's the situation that we have.
Thank you. That's all I have.
Commissioner Karen, I apologize.
Thanks. So when the call comes in from presumably the first responders of Norfolk, and it goes to Operations Center, and it's sent to the rapid response team,
Yes,
and someone is designated to go
yes,
check out the accident, which in this case was entrapment.
yes,
And the rapid response team member essentially, through experience and past incidents, recognizes that entrapment means wires are on a car, and presumably a pole fell so the wires were low enough to be in a car. If the wires are energized, that would be dangerous.
yes,
And their job is to go and de-energize and reduce that danger, both from the occupants of the car and by the first responders, as well as him or
Right.
herself.
yes.
Is there ever been an incident where an Eversource pole stationary Eversource pole has jumped out into the road in front of a car.
Not to my knowledge.
Okay. And has there ever been an instance that you're aware of that wires just fell off a pole onto a car? Eversource wires.
It certainly is possible that wires for whatever reason fell down due to wind or a variety of reasons. It's certainly entirely possible, or just a failure, a splice failure. It has happened where wires fall down without an obvious anything striking it.
So except for what seem to be outlier instances, it's essentially for whatever reason, a driver striking an Eversource equipment, causing damage and or outages, and may or may not have an energized line that has to be dealt with by the response team.
Yes.
So the response team member gets to the scene, and his primary responsibilities are what?
Well, again, the first responsibility is to make the scene safe.
By doing what?
So by assessing the situation, making a determination of whether there or not there are energized wires that are in the vicinity of the incident. Speaking with the incident commander to make the incident commander aware of any potential danger with energized wires, and to let the incident commander again know that this is what the plan is or what needs to be done to make the scene safe. So typically they would take whatever action is necessary to de-energize those wires, and then proceed to whatever needs to be done to clear the area so that the first responders can attend to the accident victims.
Because now it's safe.
Because now it's safe, yes.
And was there any other Eversource employee at the scene that was de-energizing and making the area safe? To your recollection.
So I know, again, because of the severity of the information that was received, I know that more than one responder was directed to the scene. There were one or more first responders, line workers, response specialists. There were also supervision that was responded to the scene. I don't know all the details as, I believe it's in the underlying docket as to who responded and what times they responded, but there were numerous, resources that were directed to the scene.
Okay, so the response team member makes the scene safe within, I think it was 2 or 3 minutes. He was not injured in accomplishing the goal and the task, and no other Eversource employee was injured.
That's correct.
And from there, what are the responsibilities of the response team member from there?
So to restore service, if there was a loss of service as a result of the accident, if there were outages, and also to complete any repairs. And there may be, multiple steps in doing so.
So that person is doing that right after they de-energize the line. They go and start assessing their own equipment, identifying what repairs have to be made, and proceed to do that.
Yes.
And then they go back in their truck and go about their day?
Then pretty much could report back that they're, completed, the scene is, made safe, power has been restored, repairs have been made, and they're available for the next call.
So in terms of the report, it would be relevant. The only real relevance, it seems, is that the response team members' responsibilities to make the area safe, make repairs, and restore power as soon as possible, and then get on with his or her day.
That's the typical process, yes.
And once the report is being done, so in other words, Eversource doesn't need to know and has no reason to know whether a non-employee was injured or not injured, because it has nothing to do with reestablishing a safe area and power into the system so they can operate safely again.
That's correct. It's not relevant to our duties.
But if an Eversource employee had been injured, that would have relevance to the safe operation of the distribution system as you'd be down a person and would have to supplement that one way or another with another FTE somehow during
Would
the
have
course of the
to
day. or week.
supplement as well as use additional resources that are on site to attend to that individual ourselves.
So again, so that's, so I guess I'm just trying to understand. So there apparently is no relevance to Eversource as to any injuries that have nothing to do with the safe operation of the distribution
I
system.
mean, obviously, we're
Not that you don't care,
yeah,
but
we
it has no
care, we're
relevance
concerned
to,
that
primary
it's
purpose.
not, it's very unfortunate that there's injuries to anyone. But it's not, it's not relevant to the task at hand, that the task, the assignment that our response specialists are tasked with is make safe, restore service, make repairs. And that's whether or not there are, unfortunate injuries to other members of the public is not relevant to our task.
So in their job description and or their, what's required of them when they go to a scene is not to assess injuries of anyone other than making the place safe.
That's correct.
Do the response team members have medical training and or first aid training or not? To your knowledge?
They have some basic first aid training for if there are, to respond to an injury to a fellow employee. But they don't have an in-depth medical training.
So they wouldn't be expected to treat anybody who
No,
seems to be seriously injured
No,
or not seriously injured. I mean, somebody could
No, they would not be expected to treat anyone.
or assess.
Or assess. They're not trained to do that whatsoever.
Let me go back to the forms here. So so in the packet of the pre-filed testimony, there were a number of examples or illustrations of past reports showing blank spaces where essentially was not applicable and other boxes that were filled with pertinent information.
Yes,
Was that a representative sample, or was that all of the incident reports that you're aware of from 2013 forward?
That was a sample. And what we did is we just went back and we took, at least one example at the beginning of each year
Okay.
to basically show that this was a consistent practice.
When you submit the immediate report through the PURA portal, excuse me, is that addressed to anyone in particular at the authority?
Not to my knowledge. I don't handle that part of it. Our regulatory group does, so I can't specifically speak to that.
Okay. I'm sorry, I just have trouble reading my own writing. Colors don't actually help. Okay, Madam Chairman, I think that's it for me. Thank you.
Is there any redirect?
I could have 5 minutes to talk with the witness.
Okay.
Okay, Mark, come on in. Oh.
Attorney Crisp.
Yes, we have no redirect.
All right, thank you. We will upload the date into the external calendar for when briefs are due. So thank you very much for answering our questions here today, and